Greetings, Sanbonani, Dumelang. I'm back with another video where we're carrying on with the basic conditions of employment. I know in the two previous videos we dealt with the grievances and the notice for disciplinary hearing, because I thought those ones were a bit urgent, so we needed to deal with those ones, address those ones as quickly as possible. So now we go back to the basic conditions of employment. We're still dealing with the leave as per the basic conditions of employment. So right now we're going to be dealing with the maternity leave. In terms of Section 187, subsection 1E of the Labor Relations Act 1995, the dismissal of an employee on account of her pregnancy, intended pregnancy, or any reason related to a pregnancy is automatically unfair. The definition of a dismissal in Section 186 of the Labor Relations Act 1995 includes the refusal to allow an employee to resume work after she has taken maternity leave in terms of any law, collective agreement, or her contract. Number one, an employee is entitled to at least 4 consecutive months maternity leave. Number two, an employee may commence maternity leave at any time from 4 weeks before the expected date of birth, unless otherwise agreed, or on a date from which a medical practitioner or a midwife certifies that it is necessary for the employee's health or that of her unborn child. Number three, no employee may work for 6 weeks after the birth of her child unless a medical practitioner or midwife certifies that she is fit to do so. Number four, an employee who has a miscarriage during the 3rd trimester of her pregnancy or bears a stillborn child is entitled to maternity leave for 6 weeks after the miscarriage of stillbirth, whether or not the employee had commenced maternity leave at the time of the miscarriage or stillbirth. Number five, an employee must notify an employer in writing, unless the employee is unable to do so, of the date on which the employee intends to commence maternity leave and return to work after maternity leave. Number six, notification in terms of subsection 5 must be given at least 4 weeks before the employee intends to commence maternity leave, or B, if it is not reasonably practicable to do so, as soon as it's reasonably practicable. Number seven, the payment of maternity benefits will be determined by the minister, subject to the provisions of Unemployment Insurance Act of 1996. Section 34 and 37 of the Unemployment Insurance Act number 30 of 1996 provide for the payment of maternity leave. Legislative amendments will be proposed to Cabinet to improve these benefits and to provide that the payment to an employee of maternity benefits does not adversely affect the right to unemployment benefits. All right. Number 26. Protection of employees before and after the birth of a child. Number one, no employer may require or permit a pregnant employee or an employee who's nursing her child to perform work that is hazardous to her health or the health of her child. The minister must issue a code of good practice on the protection of employees during pregnancy and after the birth of a child in terms of Section 87 Section 87 subsection 1B. During an employee's pregnancy and for the period of 6 months after the birth of a child, her employer must offer her suitable alternative employment in terms and conditions that are not less favorable than her ordinary terms and conditions of employment, if the employee is required to perform night work as defined in Section 17 subsection 1 of her work poses a danger to her health or system of that of her child, or safety or that of her child, and it is practicable for the employer to do so. I think, guys, now we get it, that how is the maternity leave regulated. We know in some cases workers don't enjoy these rights, so it's very important that you know these rights, the maternity leave, how that situation is handled, and what are your benefits, what is that you're entitled to. Thank you very much, guys, for watching. Please subscribe, please share the channel, share the video with others as well. Sedi Raleboa.